Welcome everyone to today's deep dive. I'm your host, and today we're essentially taking a sledgehammer to the ultimate legal cliche.
You mean the gavel.
Right, exactly. The gavel. Everyone focuses on that image. It's the whole icon of the legal system. The judge sits up high, listens to a few arguments, gets a gut feeling, and then bang, smashes the hammer down. Guilty or not guilty.
Something
It's
about that.
definitive, right? It's dramatic.
It is. But I'm the resident expert here today, and I have to tell you, that dramatic moment, it's basically just theater at that point.
Just theater.
Yeah.
Yeah.
I mean, the real work, the actual heavy lifting, happens in the total silence before that strike.
And that is exactly what we're digging into today. Because we aren't looking at the drama of the courtroom, we want to look at the actual mechanics of the judicial mind. We're basing this whole deep dive on a really fascinating source, The Anatomy of Judicial Adjudication by M. Usman Khan, advocate.
It's a fantastic text. Very thorough.
Yeah, and it makes this incredibly bold claim right up front. The source says that judges don't just, declare justice like they're picking a winner in a boxing match. They have to actually construct it.
Exactly. It's a manufacturing process, really.
Mm.
A judgment isn't just an opinion someone throws out there. It's a product, and it has to be built. And if you build it with the wrong materials or faulty blueprints, the whole thing just collapses on appeal. That's the core concept we're dealing with here, a reasoned judgment.
I really love that distinction, reason versus declared. It sort of turns the judge from a king handing down a decree into something more like an architect or a mathematician. So our mission for this deep dive is to basically tear apart that construction process.
We're going to get under the hood.
Right. We're going to look at the raw materials, which are the laws and the legal maxims. Then we'll look at the rigorous logic judges use to process facts and evidence. And finally, we're going to apply all of that theory to a very specific, incredibly high-stakes arena, which is banking litigation.
Which is where the rubber really hits the road. We're going to see how the U.S., the U.K., and Pakistan handle these massive billion-dollar corporate disputes. And trust me, the differences between those countries are wild.
I can't wait to get to that part. But let's start at the foundation. If I'm a judge, I can't just walk into the courtroom, look at the defendant, and say, yeah, I think that guy looks guilty.
No, you definitely cannot.
Right. I have to start with what the source calls the applicable law. And the text highlights this inherent tension immediately with the concept of stare decisis.
Right, stare decisis. It roughly translates to stand by things decided. And this is really the first shackle a judge has to put on when they sit at the bench. You have to look at what previous judges, specifically judges in higher courts, have done when they were presented with similar facts. It's all about binding precedents.
Okay, but let me play devil's advocate here for a second. Isn't that a bit suffocating? If you're a judge and you're forced to follow a decision made 50, maybe 100 years ago, how does the law ever evolve? It kind of feels like you're just photocopying the past.
And that right there is the eternal tension in the law. But think about the alternative. If you don't follow precedent, you just get total chaos. Imagine if the legality of your apartment rental contract depended entirely on which specific judge you happened to get on a random Tuesday morning.
Oh, that would be a nightmare.
Exactly. The system absolutely needs predictability to function. People need to know what the rules are. But you're right, if you stick too rigidly to stare decisis, you just end up perpetuating old mistakes. So, the source argues that a judge's real job isn't just blindly copying. Their job is to find the ratio decidendi within that older precedent.
The ratio decidendi, that's the reason for the decision, right?
Yes, and identifying that is a highly critical skill. Because a previous judgment might be 100 pages long, 90% of that document is just fluff. It's facts specific to that particular day, descriptions of the weather, random arguments lawyers made, whatever. The ratio is the single core legal principle that actually drove the final outcome. That's the only part that is strictly binding on future cases.
So a really good judge is basically a surgeon. They have to carefully cut out the core principle from the old case and transplant it into the new one, leaving all the irrelevant stuff behind.
Precisely. That's a great way to put it. And alongside those precedents, judges are constantly navigating these ancient Latin maxims. And look, I know Latin sounds incredibly dusty and academic to most of us, but some of these maxims are surprisingly brutal when you see them applied to real life.
Oh, for sure. The one from the source that always trips me up is ignorantia juris non excusat. Ignorance of the law excuses no one. I mean, I get the theory behind it, but in practice, there are literal millions of laws on the books. Tax codes, weird local zoning bylaws, massive banking regulations. It feels inherently unfair to say to someone, well, you should have known, when literally nobody on earth knows everything.
It definitely feels unfair to the individual, but again, you have to look at the alternative. If ignorance was suddenly a valid legal defense, the entire justice system would dissolve overnight. Every single person caught speeding or evading taxes or dumping chemicals would just stand up in court and say, "Oh, my bad, I didn't know that was illegal."
And the state couldn't prove otherwise.
Exactly. The prosecution would have to prove beyond a reasonable doubt what was inside the person's head, that they actually did know the specific statute. It would be an impossible hurdle.
So the system basically prioritizes overall efficiency over individual fairness in that specific instance. It's almost like a pragmatic lie. We all just agree to tell each other. Everyone knows the law.
It is a pragmatic lie, yeah.
Yeah.
But then the source points out the counterbalance to that harshness, which is another maxim, ubi jus, ibi remedium,
Mm.
which means where there is a right, there is a remedy.
Now that one feels a lot more hopeful.
It's basically the anchor of civil liberty. It means that if the state grants you a right, let's say the right to privacy or the right to free speech, but provides absolutely no legal mechanism for you to sue someone who violates that right, then you don't actually have that right at all.
It's just words on paper.
Right. It's just poetry. A judge's job is to ensure that the actual machinery of the court delivers a tangible remedy. If the law is just a ghost, the judge has to give it a physical body.
Okay, so we've got the laws, the precedents, and the maxims. That's essentially the rule book. Now we need to look at the game itself, the evidence. The source calls this next phase the appreciation of evidence, which honestly sounds like we're standing in a gallery admiring a painting, but it's actually a really strict filtering process.
It's entirely a gatekeeping process.
Yeah.
And this is where the layman's view of how court works gets it completely wrong. We all tend to think court is about finding the truth, truth with a capital T, but it's not. It's about what is admissible.
Meaning, as an example, I could know for an absolute fact that you stole my car. I could literally have a high-definition video of you doing it. But if I obtained that video by illegally hacking into your private cloud
The
account,
judge is going to throw it right out. It's inadmissible. In the eyes of the court, that video simply does not exist.
right.
And the judge actually has to wipe it from their own mind. This is why building the judicial mind requires so much discipline. You have to actively ignore what you clearly know to be true if it violates the rules of the Evidence Act. And that applies whether you're in the UK, Pakistan, or following the federal rules of evidence in the US.
Wow. That naturally leads us to the burden of proof. And the source breaks this down mathematically in a way that I think will clear up a ton of public confusion, because we see stuff on the news and we constantly mix up the criminal standard with the civil standard.
Oh, it's a huge difference.
Mm.
In a criminal trial, the state is trying to literally take away your liberty, or in some places, your life. The stakes are infinite. So the standard of proof there is beyond a reasonable doubt.
Which, importantly, doesn't mean beyond a shadow of a doubt.
No, it doesn't. It means there is no other logical explanation that can be derived from the facts, except that the accused is guilty. If the defense can present a plausible, logical story where you didn't do it, then you walk free. The burden is incredibly high.
But then when we pivot to civil or corporate litigation, which is where our banking discussion is heading, that standard just drops off an absolute cliff.
It drops down to the preponderance of probabilities, the 51% rule.
This is the part that genuinely scares me about ever getting sued. You don't have to prove that I definitely 100% breached a contract. You literally just have to prove it's slightly more likely that I did than I didn't.
Exactly. Imagine a set of scales. In a criminal trial, the prosecutor needs to slam their side of the scale all the way down to the floor. In a civil trial, if you put a feather on one side of the scale and it tips just 1 millimeter, you win. You win the whole pot.
Which perfectly explains things like the O.J. Simpson trials.
Yes, the classic example. Acquitted criminally because the prosecution couldn't reach that 99% threshold, but found liable civilly because the plaintiffs very easily cleared that 51% threshold. It was more likely than not that he did it.
Keeping that 51% rule in mind is crucial for what comes next. The source outlines the machinery of adjudication. It details the actual 3 phases a judge goes through to build that reasoned judgment we talked about. Phase 1 is the framing of issues.
And honestly, this is the most underrated part of the entire legal process. Before hearing a single witness, the judge has to look at the messy, chaotic arguments from both lawyers and say, okay, stop, what are we actually fighting about here? They have to meticulously separate the questions of fact from the questions of law.
And this is where the concept of locus standi comes into play.
Right. Locus standi. Standing. Does this person even have the legal right to be standing in this room making this claim? If a judge frames the issues incorrectly or lets someone argue a case who has no actual standing, the whole trial is just a giant waste of time. It's exactly like setting up a chessboard. If you accidentally put the king on the wrong square, the entire game is invalid before anyone even makes the first move.
So that's phase one. Phase two is that appreciation of evidence we just touched on earlier, weeding out the inadmissible stuff and weighing the credibility of witnesses. But phase three is where the magic happens. This is my favorite part of the source. The syllogism of law. It sounds like a wizard spell, but it's actually just pure cold logic.
It's the foundational formula that saves a judgment from just being an arbitrary gut feeling. A syllogism requires three parts: a major premise, a minor premise, and a conclusion. In law, the major premise is the law itself. The minor premise represents the facts of the specific case. Combine them, and you get the conclusion, which is the judgment.
Let's construct one for the listeners. Let's use a contract example since we're heading straight into banking.
Go for it.
Okay, so the major premise. The law states that a signature on a contract is binding, completely regardless of whether the signer actually read the document. Now, the minor premise. The facts show the defendant did sign the loan agreement, but he claims he was too busy to read the fine print.
And the conclusion basically writes itself. The defendant is liable. The judge doesn't have to feel that the defendant is wrong. The judge doesn't have to dislike the guy. The logic dictates the outcome. If both premises are true, the conclusion simply must be true.
It's incredibly cold, isn't it? I didn't read it as such a profoundly human excuse. We've all done it. But the syllogism does not care.
The law can't afford to care about that kind of excuse, especially not in commercial matters. If I was too busy to read it was accepted as a valid minor premise to void a contract, the entire global banking system would collapse by tomorrow morning.
Which is the perfect bridge to the second half of our deep dive. We're moving out of the abstract judicial mind and stepping into the concrete jungle of banking litigation. The source provides this amazing comparative analysis of how the US, the UK, and Pakistan handle these disputes. And the overwhelming headline here seems to be, banks need their money and they need it fast.
That is absolutely the headline. Financial institutions survive entirely on liquidity, cash flow. If a corporate borrower stops paying a massive loan and the bank has to spend 5 to 7 years in a traditional court trial to get that money back, the bank goes under. So the legal systems in all three of these jurisdictions have developed what are called summary procedures. They are specifically designed to shortcut the usual drawn-out trial process.
But they go about it in very, very different ways. Let's start with the United States. We all know the U.S. is a highly litigious culture. What's the defining characteristic of their summary procedure?
In the U.S., under Rule 56 of the Federal Rules of Civil Procedure, you have summary judgment. But the real weapon in the U.S. system isn't the judgment itself, it's discovery.
Pre-trial discovery. We see this in legal thrillers all the time. A conference room just stacked to the ceiling with cardboard boxes full of files.
Exactly. But in reality, it's weaponized boredom and weaponized expense. In the U.S., the pretrial discovery rules are incredibly broad. If a bank sues a major corporation, or vice versa, the lawyers can demand millions of internal emails. They can demand day-long depositions of every single mid-level executive, all the internal memos. It costs an absolute fortune just to locate and process the documents before you ever see a judge.
So the actual strategy for the lawyers isn't necessarily, I have a better syllogism and I will win at trial. The strategy is, I will completely bankrupt you with legal fees during the discovery phase so you are forced to settle.
You nailed it. It forces a financial resolution before the judge even has to frame the issues. Now, compare that aggressive system to the United Kingdom.
Right. The UK, they use Part 24 of the Civil Procedure Rules for summary disposal. But the thing in the text that really stood out to me was their cost structure, what they call the English rule.
Oh, this is easily the scariest rule in global litigation. Costs follow the event, simply translated. The loser of the lawsuit pays the winner's legal bills.
That is genuinely terrifying. So if I decide to sue a major bank in London because I firmly believe they overcharged me on some fees and I end up losing the case, I don't just lose my claim. I have to pull out my checkbook and pay for their entire team of $1,000 an hour corporate lawyers.
Yes, you do. And that dynamic creates a massive, massive chill on frivolous litigation. You have to be incredibly sure of your minor premise, your facts, before you ever step foot into a British courtroom. In the U.S., you can take a wild shot, and if you lose, well, you just pay your own lawyer. In the UK, you are literally betting your house on your syllogism.
Wow. Okay. Then we look at Pakistan. The source discusses their specialized banking courts under the Financial Institutions Ordinance of 2001. There's a specific mechanism outlined there called leave to defend. This sounded totally unique compared to the West.
It is very unique. In a normal, everyday civil lawsuit, you have a natural, inherent right to defend yourself. If I sue you, you just get to file a reply saying, no, I didn't do it. But in Pakistani banking courts, the entire presumption shifts heavily in favor of the bank. The debtor receives the court summons, and they can't just file a standard defense. They actually have to file a petition for leave to appear and defend, or a PLA.
Wait, let me make sure I'm getting this. You have to literally ask the judge for permission to defend yourself.
Essentially, yes. You have to convince the judge right out of the gate at the very start of the process that you have a substantial question of law or fact. If your proposed defense is just, I don't have the money right now, or you just offer vague, blanket denials of the debt, the judge can reject your PLA entirely and pass judgment for the bank immediately.
Boom. Game over right there. No trial.
Game over. It's a procedure designed specifically to stop the culture of stay orders, where corporate debtors just use legal loopholes to drag debt recovery out for 10 years. It forces the issue immediately. Show us a real factual argument right now or pay up.
That's fascinating. It's like installing a highly aggressive bouncer on the front door of the courthouse. The source also gets into the weeds with a banking taxonomy, listing specific types of disputes these courts handle. We definitely can't cover them all today, but I do want to highlight letter of credit disputes, because the text mentions a framework called UCP 600.
This is critical for anyone interested in global trade. A letter of credit is, at its core, a bank guarantee. If I'm a buyer in New York purchasing 10,000 shirts from a factory in Vietnam, I don't want to hand over my cash until I know the shirts are on a boat. But the factory doesn't want to put the shirts on the boat until they know for sure they'll get paid.
So the bank steps in to sit in the middle and hold the risk.
Exactly. And the UCP 600 are the internationally recognized rules that govern how banks handle those letters.
And the strictness described here is wild. The source implies that if a shipping document has a tiny typo, the bank can just straight up refuse to release the payment.
Welcome to the doctrine of strict compliance. If the letter of credit specifically says 1,000 blue cotton shirts and the factory's invoice says 1,000 blue shirts cotton, the bank absolutely can and often will reject the document, because the bank deals strictly in documents, not physical goods. They aren't sending an executive down to the loading dock to touch the fabric. They're only checking if paper A perfectly matches paper B.
So it comes right back to that cold logic of the syllogism again. Does document A match document B? If no, then payment is denied. Logic entirely overrides feeling or common sense.
Always. And then you look at anti-money laundering cases, or AML. In these disputes, the judge's role gets even more complicated. They aren't just checking documents. They have to decide if a bank should have known that a specific transaction was suspicious.
That phrase, should have known, seems incredibly tricky for a judge to handle. It's so subjective.
It is tricky. It's essentially an objective test being applied to a subjective mind. The judge has to look at the bank's Know Your Customer, or KYC files, and decide, would a reasonable, competent banker have spotted this money laundering scheme? If the judge's answer is yes, then the bank is found legally negligent.
Taking a step back from all this, when you really look at the whole picture, the ancient maxims, the strict rules of evidence, these aggressive banking procedures, you start to realize that a reasoned judgment is actually a very fragile thing. It's a house of cards. If a judge gets one single piece wrong, does the whole thing just fall apart?
It absolutely does. And there's a very specific legal term for a judgment that fails this rigorous construction test. It's called per incuriam.
Per curiam.
It translates to through lack of care. If a judge writes a 50-page judgment but forgets to mention a binding stare decisis precedent, or completely ignores a key piece of admissible evidence, or crucially if they fail to complete the syllogism logically, that judgment is declared per incuriam.
So it's not just categorized as a bad call by the referee, it's technically legally void?
It becomes highly liable to be set aside by an appellate court. It's a defective product. The legal system itself acknowledges that if the judge didn't show their work, or if the underlying logic is sloppy, the result is not justice, it's just noise.
And that's exactly where I want to land this deep dive today. We've been talking nonstop about judges and courts, but this whole framework, it's actually a really powerful practical tool for our own daily lives.
I completely agree. Because we are all adjudicating things every single day. You decide who to trust, who you're going to hire, which news story on your feed you're going to believe.
But the real question is, do we actually take the time to build a reasoned judgment for those things? Or are we all just sitting around banging our own little gavels?
Think about the syllogism we discussed. The next time you get into a heated argument with your partner or a colleague at work, can you actually articulate your major premise? Are you saying, I'm angry because you violated agreed upon rule X, or are you just feeling angry and lashing out?
Right. And are we checking the admissibility of our own facts? If you hear a juicy rumor about someone you don't like, do you discipline your mind to treat it as inadmissible hearsay? Or do you just blindly accept it as the truth because it fits your narrative?
Sadly, most of us operate on a preponderance of probability, or even way less than 51% when it suits our personal biases. We gladly accept incredibly weak evidence if it confirms what we already want to believe. But then, we suddenly demand proof beyond a reasonable doubt for any information that challenges our worldview.
It's human nature. So the challenge for everyone listening to this deep dive is this. The next time you have to make a big, important decision, try to actually write out the judgment in your head. Frame the issues properly. Check your evidence for admissibility. Build a logical syllogism.
Because if you don't take the time to do that, your life decisions might just be per incurium. And life, unfortunately, doesn't always provide you with a court of appeal to fix your mistakes.
A very sobering thought to end on. We really hope this look inside the judicial mind helps you construct much better, reasoned decisions in your own life. Thanks for taking the time to join us on the deep dive.
See you next time, everyone.